a very good afternoon. It's 5 minutes short. It could be a morning batch afternoon. Ladies and gentlemen, it gives me immense pleasure to address this gathering of young law students, curious minds, particularly in an institution which is dedicated to legal education of women. I'm happy to see the future of the legal profession sitting right before me today. I often reflect on how differently the law presented itself when I was a young law student. And I'm talking of mid-80s, early 80s. At that time, search required patience, physical effort, and perseverance. We used to spend long hours in the library poring over commentaries, over digests, and technology did exist, but it did not define our engagement with law. Today, many of you encounter the law first through a digital interface. Judgments are downloaded, filings are uploaded, hearings are streamed through video conferencing, disputes are many times resolved entirely online. The shift is not merely technological, it is jurisprudential. This shift is how it alters that rights that are exercised, how obligations are enforced, and how justice is accessed. Over the years, initially as a legal practitioner and later on as a judge of the Supreme Court, I have witnessed how technological questions have slowly but steadily moved from the periphery to the very center of the constitutional discourse. Electronic evidence, digital speeches, data protection, internet shutdowns, intermediary liabilities, these are no longer matters of academic curiosity. They have become a pressing constitutional challenge that each of us are facing, and so will you, at a more heightened form by the time you join the profession. It is against this backdrop that I propose to explore the theme for today's lecture, which is technology and the legal system, from tech laws to tech in law. Broadly speaking, there are two dimensions to this evolving relationship between technology and the legal system that unfolds through two interconnected strands. First, technology as a subject of law, which means how we regulate digital content, protect rights, impose accountability. The first part of my address proposes to trace the contours of India's technology law, the statutory and the judicial responses fashioned to regulate digital conduct, safeguard individual rights, and address the emerging vulnerabilities of cyberspace. The second part shall deal with technology as an instrument of law, that is, how it transforms judicial administration and dispute resolution. This section shall turn its gaze inwards to examine how technology has entered the portals of the judicial system, itself acting as a tool to render justice, supporting administration and governance, and expediting adjudication without displacing human empathy that lies at the very core of justice dispensation. Together, these two strands, technology governed by the rule of law and technology harnessed in the service of law, frame the theme of my address. Coming to the constitutional challenges of digital scale, technology has truly become an integral facet of our lives. Today, internet is the default doorway of our daily life. We purchase air tickets, we pay taxes and settle utility bills without leaving our tables, transforming what once demanded physical presence into digital case. This pervasive integration is borne out by empirical data. By the end of the year 2025, that's last year, more than 6 billion people were connected to the internet, with India alone accounting for 1 billion users. What was once an exception is now the rule, and what was once experimental has become a routine matter. However, ubiquity brings complexity. The scale of technological change that we are witnessing today places new demands upon law, as digital platforms, data-driven systems, and AI increasingly shape economic activity, social interaction, and public administration. The law is required to govern conduct in areas that are often borderless, fast-moving, and technologically complex. The Constitution that was drafted in the age of the ink and the paper now governs a society that is increasingly living in and communicating in the cloud. The law must therefore perform a delicate balancing act, encouraging innovation while safeguarding constitutional guarantees. It is in response to this emerging digital landscape that our nation's formal engagement with technological regulations began. So, what is the evolution of technology law in India? Let us start with the year 2000. The journey of our country into digital regulation commenced with the enactment of the Information Technology Act in the year 2000. The statute was conceived as an enabling framework designed primarily to accord legal recognition to electronic records and digital signatures, and to facilitate the growth of electronic commerce and e-governance. At the time of its enactment, Internet in India was largely transactional in character and modest in scale. It had yet to assume the expansive and data-driven character that is defined by it today. At that time, law was not grappling with social media platforms, not with viral misinformation or the algorithmic amplification or even the large-scale data surveillance. Instead, its focus was on fundamental foundational questions, as for example, could an electronic communication constitute a valid contract? Could a digital signature substitute a handwritten authentication? Could governmental processes migrate into electronic form without compromising its legal validity? This act answered these questions in the affirmative, yet it did so within the technological imagination of that time. It did not and perhaps could not foresee the velocity and the scale of the digital transformation that would follow. As technology evolved far beyond these horizons, law was compelled to expand its vision. The focus gradually shifted from merely recognizing electronic transactions to regulating intermediaries, to addressing cyber offenses, to engaging with deeper questions of rights, of accountability, and of institutional power in the digital spheres. What began as a facilitative statute evolved over time into more regulatory and rights-sensitive framework. In this transition, the judiciary has played a vital interpretative role. Look at the few examples that I can randomly share with you. Take the Shreya Singhal case, you all would be familiar with it. That was a case of the year 2015, or more than a decade ago. It was a case where the petitioner, among others, was a law student, and that will engage you, who approached the Supreme Court challenging the constitutionality of Section 66A of the IT Act that criminalized sending what was called offensive and annoying messages via computer resources or other devices like the mobile, and it carried imprisonment as a punishment up to 3 years. While striking down this provision as a violation of Article 19(1)(a), which is freedom to speech, the Supreme Court reaffirmed that speech does not lose its constitutional protection merely because it is expressed online. The court emphasized that vague and overbroad restrictions on expression have no place in the constitutional democracy. Equally significant was a clarification that intermediaries could not assume the role of private censors without judicial oversight. Content could be removed only by the court or a lawful direction issued by the government. In doing so, the court ensured that digital regulation remained anchored in the constitutional framework. A similar emphasis on doctrinal clarity emerged in Sharat Babu Dignitaries versus Government of NCT, which was a case of the year 2017, 2 years after Shreya Singhal's case, where Supreme Court clarified that where offences concern electronic records, the IT Act operates as a special statute and it prevails over the General Act, which is the IPC. This interpretation preserved coherence in cyber prosecution and prevented fragmentation across overlapping statutory regimes. Read alongside Shreya Singhal, the decision reflects a consistent judicial approach, which is that regulation in cyberspace must rest upon principled statutory interpretation and constitutional discipline rather than on an ad hoc enforcement. Courts were also required over time to address jurisdictional dilemmas presented by borderless internet. In the early years, mere accessibility of the website within a particular territorial jurisdiction was sometimes treated as sufficient to confer jurisdiction on a particular state high court. Over time, this approach matured. Courts increasingly required evidence of purposeful targeting of users within its jurisdiction before entertaining a petition. This refinement reflects a recognition that digital presence alone cannot justify universal adjudicatory reach. In the year 2008 came the amendments to the IT Act, which introduced certain safe harbors under Section 79 that protected intermediaries from liability for third-party content, and yet there were concerns about overbroad private censorship. So, in Google India, which is a 2019 judgment, the Supreme Court reaffirmed that actual knowledge under Section 79 arises only on receipt of a court order or a government notification. Intermediaries cannot be compelled to remove content merely on the basis of a private complaint. By reinforcing the standards set down in Shreya Singhal, the Supreme Court sought to curb arbitrary takedowns and protect online speech from excessive private censorship. As digital platforms began operating over the years at an unprecedented scale, courts were required to deal with limits of territorial remedies themselves. Then came in the 2019 Swami Ramdev case, where the Delhi High Court held that where unlawful content originates in India or is directed towards Indian users, platforms may be required to remove it globally, not merely restrict access within the national boundaries. Reason being that in a medium without borders, geographically confined remedies risks rendering judicial orders as ineffective. This decision underscores that evolving complexities of cross-border enforcement is important in digital spaces. The evolving understanding culminated in the enactment of the Information Technology Rules of 2021. The rules recognize that digital platforms are no longer passive conduits. They are curated, amplified, and they monetize speech. Regulatory obligations have therefore been calibrated to scale. Significant social media intermediaries have been subjected to enhanced compliance requirements, which includes appointment of resident grievance officers and periodic transparency reports. The framework now acknowledges a conceptual distinction between the platform, which facilitates the communication, and the publisher, who shapes the content. For a long time, the law has regulated the highway while leaving the driver comparatively untouched. As digital news portals and streamlined platforms began to rival traditional media in influence, this imbalance required calibration, and thus came the Digital Media Ethics Code, sought to address it through structured transparency and responsible self-regulation rather than censorship. The regulatory framework continued to evolve, and the amendments to the IT rules that were notified just this month on 10th of February 2026 reflect a further development, particularly in response to AI, and deepfake technologies. In an era where artificial intelligence can replicate voice, replicate image and likeliness with unsettling accuracy, authenticity itself has become a matter of legal concern. The rules now recognize synthetically generated information and impose obligations on intermediaries to deploy reasonable and proportionate technical measures to prevent unlawful AI-generated content. Where such content is permissible, it must be clearly and prominently labeled, accompanied by metadata or provenance markers to ensure traceability. Significant intermediaries are also required to obtain user consent and declarations in relation to synthetic content. These measures signal a shift from reactive modernization to anticipatory regulation. In an era where AI can replicate voice, image, likeness, and with unsettling accuracy, authenticity itself becomes a matter of legal concern. Viewed in its entirety, the evolution of technology in India reflects a gradual but a steady movement from facilitation to regulation, from regulation to constitutional collaboration. What began as a framework to validate electronic transactions has by now matured into a regime attentive to platform power, to cross-border complexity, and now the integrity of the digital content itself. The underlying principle, friends, remains the same. It's constant. Technology and its expansion must be accompanied by corresponding legal responsibility, and innovation must remain subject to constitutional values. May I now touch upon cyber crimes, which is something which we hear about so often now, and its legal response. Even as the law strengthens protection for autonomy and data rights, it must confront a parallel reality, which is the rapid digitization of crime. The technologies that enable connection and convenience also have enabled deception of a large scale. Today, cyber crimes represent a convergence of technological sophistication and psychological manipulation. Ransomware attacks can disable critical infrastructure. AI-driven phishing schemes mimic trusted voices and institutions. Fraudulent investment platforms exploit digital confidence. Deepfakers are deployed for blackmail and misinformation. These are not entirely new offenses in substance, but they are new in form and in reach. They exploit anonymity, speed, and the absence of territorial boundaries. For example, in recent months we have witnessed the disturbing phenomena which is described as digital arrest, where frightened citizens receive call from fraudsters impersonating police or the investigating agencies, and they are told that they are under investigation for some grave offense, and then coerced into transferring money to avoid what is called arrest. It is a chilling invasion of the constitutional authority. The language of law is used now as an instrument of fear. It is not merely a cyber nuisance, but a grave assault on public trust and on financial security. Taking suo motu cognizance of this, the digital arrest and the fakes and the crimes taking place under the garb of digital arrest, the Supreme Court, while describing these scams as nothing short of robbery and dacoity, has recently observed that over 54,000 crores of rupees have been siphoned off through such frauds from April 21 to November 25. Recognizing the gravity of these offenses, the Supreme Court further issued binding directions to all authorities to implement the standard operating procedures nationwide. In a recent matter before the Supreme Court, an 82-year-old man living alone became the victim of what was described as one of the largest individual digital fraud cases in India. Cyber criminals allegedly impersonated Mumbai police officials and the telecom authorities, sending him forged Supreme Court orders and forged RBI orders through WhatsApp messages and video calls. Under relentless psychological pressure and threats of arrest and seizure of property, this senior citizen was coerced into transferring his life savings of about 22 crores to the scamsters. This episode is a stark reminder that digital fraud today is not merely technological in execution, but profoundly human in its impact, often targeting those who are most vulnerable and least equipped to navigate a rapidly digitized world. We must pause here to reflect on the human cost that lies behind these staggering numbers. Elderly parents losing their savings of a lifetime. Young professionals watching years of earning disappear within hours. And families left with a lingering sense of shame, of fear, and helplessness. In many instances, such as the one I've just described, fraudsters have gone to the extent to forge court orders and misuse names of constitutional authorities, creating an atmosphere where citizens began to doubt the entire digital system, but also, sadly, the institutions that are meant to protect them. It is for this reason that coordinated national action has become imperative. It is a constitutional democracy of our nature. No citizen should ever be made to feel that their liberty can be negotiated through a screen or purchased through a bank transfer. The authority of law must always rest on due process, transparency, and trust. Empirical data confirms that this is not a matter of sporadic occurrence. The Indian Cyber Threat Report 2025 records over 369 million malware detections in a single year across more than 8.4 million endpoints, amounting to hundreds of hostile cyber incidents every minute. The growing prevalence of behavior-based and zero-day attacks demonstrates increasing adaptability of the malicious actors, while the sectoral concentration of attacks in health sector, banking, hospitality highlights the immediate human and economic consequences of disruption. The geographic spread of malware detection in Tier 2 cities such as this city, Jaipur, Surat and Ahmedabad further illustrate that digital vulnerability expands as rapidly as digital penetration. In response, the statutory framework assumes renewed importance. The IT Act criminalizes unauthorized access and interference with computer systems. Then there are sections relating to capturing conduct ranging from basic hacking to sophisticated ransom attacks. There are sections that address offenses of receiving stolen computer resources, of identity threat and cheating by impersonation. There are provisions that now underpin prosecutions for phishing scams, SIM swapping frauds and OTP-based financial crimes. There are provisions to protect bodily and informational privacy by criminalizing non-consensual capture or transmission of private images. Other provisions that deal with publication and transmission of obscene material and child sexual abuse material. At the extreme end lies a provision 66F that penalizes cyber terrorism, recognizing that data intrusion can threaten our nation's security and critical infrastructure. These provisions reflect the attempt of the legislator to translate familiar categories of criminal harm into language of network and data. What is now the BNS, the Bharatiya Nyaya Samhita, IPC, ensures that digital form does not dilute liability for traditional crimes and recognizes organized cybercrime as a structured offense capable of targeting networks rather than mere individual actors. And significant evolution is a provision, section 111, that defines organized crime to specifically include economic offenses and cybercrime. carried out by syndicates. It allows enforcers to target networks of what is called a mule account. Do look up the term if you don't know the meaning of a mule account. It's interesting and it's scary. And handlers rather than just individual foot soldiers. The dual track framework also permits the prosecutors to invoke the IT Act for the Technological Act and the BNS for the substantive harm, ensuring that digital form does not become a shield against accountability. Complementing these penal measures is the Digital Personal Data Protection Act, which has come up in 2023. Unlike the IT Act, the BNS, what we call in abbreviation the DPDP Act, adopts a regulatory approach to establishing a civil and a regulatory regime by imposing obligations upon data fiduciaries and prescribing substantial momentary penalties. It recognizes digital harm often arises from institutional neglect as much as individual wrongdoing. Violations attract significant monetary penalties by shifting the focus from punishment to prevention. The DPDP Act supplements criminal law with model deterrence grounded in accountability. The effectiveness of these provisions ultimately depends on machinery of investigation. India has progressively built a specialized architecture anchored by what is termed as the NCRP, National Cyber Crime Reporting Portal, and the 1930 helpline. This system operates on the Citizen Financial Cyber Fraud Reporting and Management System, which is designed to freeze fraudulent accounts during what is called the golden hour before they leave the banking system. Yet, there's a problem. Yet this entire workflow remains fraught with challenges. Electronic evidence is volatile, attribution of digital identity is complex, and data often resides in servers that are located outside our country. Jurisdictional questions, both territorial and subject matter, frequently complicate these prosecutions. These constraints explain the gap rate between rates of registration and of conviction. They also underline a central truth, which is that robust laws are necessary, but they are not sufficient. Effective enforcement, demands technological capacity and interagency coordination and international cooperation. Even the law strengthens its penal and enforcement architecture to respond to digital wrongdoing. It must confront a more fundamental constitution question, which is the very technologies that enable surveillance, that enable detection and prosecution, are also capable of intruding into the most intimate spheres of an individual citizen's life. The challenge, therefore, is not merely how the law punishes misuse of technology. It is also how it regulates the use of technology itself. It is at this intersection between power and restraint, efficiency and dignity, that the discourse inevitably will turn to right to privacy. Right to privacy is also an important right and a very significant one in today's digital age. Regulation of technology in a constitutional democracy can never be value neutral. It must draw its legitimacy from foundational guarantees of the Constitution that secure our liberty, our dignity, and autonomy. So we are referring to Article 14, Article 19, Article 21. Technology may transform the means through which power is exercised, but constitutional values remain constant. They never yield to innovation. They discipline innovation. The most authoritative articulation of these principles have come from the watershed case of Justice K.S. Puttaswamy, a moment which our constitutional history will always remember. A unanimous decision of a 9-judges bench has recognized that privacy is not merely a fundamental right, but a natural and an inherent attribute of human existence. Therefore, it is not a concession by the state to its citizens. And at the same time, infuses freedom guaranteed under Article 19 and equality guaranteed under Article 14. This judgment rejects the argument that privacy should be confined to mere secrecy or the right to be left alone. Instead, it articulates privacy as an informational self-determination, the right of the individual to control the collection, the use, and discrimination of personal data. The court for this had laid down a threefold test, which is legality, necessity, and proportionality. In doing so, it relocated privacy from the periphery to the very center of the constitutional protection, laying the moral and legal foundation for data protection frameworks in India. And what came up after that? We had the government, the legislature, to legislate the Digital Personal Data Protection Act 2023 that translates this vision into statutory format and recognizes that trust is foundational to digital participation. Thus far, I have spoken of technology as a subject of regulation. Yet, technology has also transformed the functioning of our legal system. So I now come to technology in law and justice delivery. During the COVID-19 pandemic, which we've all experienced firsthand, technology ensured continuity in judicial functioning. When physical courtrooms across the country fell silent, the justice system did not come to a standstill in our country. Instead, it reinvented itself in real time. Judges, court staff, members of the bar worked together round the clock to ensure continuity of judicial functioning. Physical files were converted into digital records, voluminous paper books were scanned into PDF compilations, and the entire case histories were uploaded onto virtual platforms. Court functioning in many cases became nearly paperless and in spirit almost 24/7. What might have once taken weeks for logistical preparation was achieved within days through effective collective institutional efforts. Virtual courts dissolved geographical boundaries that had long shaped our justice system. Lawyers and litigants from any part of the country could participate in these virtual hearings in courts. Proceedings were no longer confined to those who could physically enter the courtroom. At the same time, this transition underscored the importance of institutional safeguards to prevent digital exclusion. Innovations such as e-Seva Kendras assumed critical importance, providing assistance to those litigants who lacked devices, even a basic phone, who needed a stable internet or digital literacy. The objective was clear. Technology must expand access, not narrow it down. A digital court could not become an exclusive court. I'll give you my personal example here. I do recall several instances from that period which demonstrate how profoundly a system can be adapted. In Delhi, we had constituted virtual benches where my brother judge then, as I was J1, had moved to Chennai. At that time, perhaps the last few flights that left Delhi before all flights were cancelled. And while I was in Delhi, brother and I were constantly holding matters on a daily basis, him from Chennai and me from Delhi, seamlessly. All matters would be sent on PDF, our discussions took place on the phone, and we conducted court through peak pandemic in the first season of pandemic. Seamlessly hearings took place, and it was as if we were sitting side by side on the bench. This discipline and decorum and the seriousness of the judicial work remained intact even in a virtual court. Similarly, when I was Chief Justice of the Telangana High Court, matters were assigned to a bench where one of the brother judges during the summer vacation in Telangana during the second phase of COVID had gone to Chicago to meet his family. And he got stuck there and he couldn't fly back. And what did we do? They were very concerned about how will they connect, and I showed them from my example of Delhi and Chennai that it will work fine even in Hyderabad. And true enough, one judge would operate from Chicago at the oddest of hours, you can imagine the time lag, and another from Hyderabad, and courts went on seamlessly through that entire period till he could fly back to Hyderabad. So, time zones don't matter. Courts can assemble from anywhere. Arguments can be heard from anywhere and addressed from anywhere. And orders were passed without interruption by digital signatures. These were not technological innovations or experiments for the sake of novelty. They showed that we were giving live demonstrations of what the institution could perform and do under pressure. They showed that with the age of digital tools, the justice system could remain accessible, responsive, and steadfast, even in the midst of unprecedented disruption. Now coming to digital transformation in Indian courts, whatever COVID-19 may have done and all that we lost in that period, it certainly gave an impetus to virtual courts, and we must accept that. This implementation was therefore, in a manner of speaking, not really accidental, because the process had started much earlier. There are 3 phases that the government had, at the Ministry of Law, had set for digitization of courts and the justice delivery system, which we call phase 1, phase 2, phase 3. We are now in phase 3 of this process. And what is the result of phase 3? That there will be fully digital and paperless courts across the country. Districts such as Kalapeta in Kerala exemplify possibilities of AI-assisted file-free courtrooms supported by fully integrated digital infrastructures, where judges work with digitized case records, automated system streamlined workflow, and traditional physical burdens of files have disappeared. Today, technology supports every stage of litigation, from electronic institution of a case and digital wakalatnamas to automated case tracking through unique identifiers, through QR-based systems. Even the traditional paper-based records are being integrated through OCR-enabled digitization that permits faster retrieval and paperless hearings. Automated notifications now inform litigants and parties about listing of orders. Digital corselets and display boards provide real-time updates. Live display boards automatically refresh, showing court numbers, case numbers, and listed items in real time. Or near real time. You can log into any court from Supreme Court downwards in any part of the country and see what is actually happening in all courts, what matter, what item, when has a court paused, how many minutes has a case taken for arguments, all of it. Video conferencing enables participation across geographical boundaries, reduces timelines, reduces costs for litigants and lawyers. Several courts have also adopted the hybrid courtroom, where proceedings take place simultaneously. Maybe a lawyer in a physical form for one party, and the other is logging in virtually, and the judge is hearing the matter physically or virtually, whichever the case may be. Such hybrid options have opened up. Judgment research portals provide free public access to judicial decisions, allowing structured searches by statute or keyword. In 25 high courts, large justice clocks have been installed, with screens displaying live and transparent data of the cases filed, cases pending, and cases disposed of. Speech-to-text tools assist judges in real-time transcription. So as the lawyer is arguing, we have a screen where it is being transcribed simultaneously for us, for the other lawyers, and those sitting in court and outside of court, virtually. This saves judicial time and improves record accuracy. Case information systems allow judges to monitor pendency and manage their docket more effectively. For students like you who are entering the profession, these developments have practical implications. Advocacy today requires clarity, it requires preparation and precision, particularly while filing written submissions. No digital platform, let me tell you and emphasize, can compensate unclear thinking or imprecise drafting. At the same time, Familiarity with digital tools is now an integral part of a professional, competent lawyer. So what are the pitfalls of AI? Let's quickly look at a few pitfalls. As we integrate AI into legal research, into drafting, into adjudication, we must also realize and recognize that technology, while powerful, is not infallible. Generative AI systems can produce responses that appear authoritative and convincing, and yet may be entirely fabricated, a phenomenon now widely described as AI hallucination. Since we are discussing technology as an instrument of law, we must also confront the pitfalls with honesty. AI can accelerate research, assist in drafting, and improve access to justice. But, and I emphasize but, it cannot replace professional judgment, ethical responsibility, or human verification. The danger lies not in technology itself, but in over-reliance on it without scrutiny. For you young students, the temptation to treat AI outputs as authoritative can be strong. Yet, duty demands that every citation that is quoted is verified, every precedent is authenticated, and every submission is carefully examined. Courts across jurisdictions are being confronted with instances where lawyers have relied on AI-generated material containing non-existent precedents, distorted questions, and even imaginary judgments. What makes this particularly dangerous is in the legal field is that authority of law rests heavily on precedent and citation. In a profession where authenticity and accuracy are foundational, the unregulated and blind use of AI can transform a tool of assistance into a source of misinformation. Recent incidents like this have happened not only in India but universally, including United States. And these risks are vivid. In US, in the case of Mata versus Avianca, it saw attorneys sanctioned after submitting a legal brief containing fictitious cases generated by AI chatbots. In Amar Singh versus Frontier Airlines, the 10th Circuit Court of Appeals in US ordered a lawyer to pay penalties for submitting filings with fabricated case references produced through AI tools. In Indian courts too, they are having to deal with this emerging challenge. The Supreme Court has recently expressed serious concerns about petitions being filed with the assistance of AI tools that contain fabricated case citations and misleading quotations, describing this practice as alarming. In short, technology must remain an aid to legal reasoning, not a substitute for it. The challenge is not whether to use AI, but how to use it responsibly. We must ensure that in our pursuit to efficiency, we do not compromise on accuracy, on integrity and trust upon which our entire judicial edifice rests. Digital tools do address decision making, but they cannot replace human thought process, judicial discretion, judicial reasoning, and constitutional interpretations continue to remain a human facet. Efficiency is desirable, but it can never come at the cost of fairness or the due process. To close today's speech, I may say that the strength of any legal system is not in its tools, but in its temperament. Technology will continue to evolve faster than statutes, faster than precedents, and perhaps even faster than our imagination. But the enduring task of law remains constant: to balance power with restraint, innovation with accountability, and efficiency with fairness. To you young students, I say that you will inherit a profession transformed by AI, digital courts, and global networks. Yet, the essence of your role will remain unchanged. You will be called upon to think clearly, argue honestly, and uphold constitutional values in environments that may look very different from what the courtrooms were in the past. Technology may alter the medium, but justice remains a constant human endeavor. As long as it is guided by the conscious, by human reasoning, and the principles laid down in our Constitution, the rule of law will endure in any age, in any form, and any circumstance. Thank you for your patience.